What we're talking about today is commercial contracts and a clause in there that is called a merger and integration clause. And what that says is what's written on the paper is the deal. There's no side deal that we made that is also part of the deal. And those are common in commercial contracts and they are enforceable. So what you do is you put a clause in there that says, I am agreeing when I sign this contract, I'm not relying on anything you told me. And that is an element of fraud. And so if they didn't rely on what you said, the contract is binding and you don't have to spend a bunch of time taking depositions, asking people what they said or what they told each other before the contract. These clauses are called disclaimers of reliance, and you can use them and the court will probably hold them to be valid when it is a contract among equal parties. If it's going to be a deal where it's a car dealer and an individual buying a car, they're not going to let the car dealer put a disclaimer of reliance in there and be able to tell the guy this is a cream puff and nobody ever drove it except on Sundays and it's never been in the rain. When they say those things, those are going to be held against a car dealer. If, however, it's two car dealers back and forth against each other and they're of equal bargaining power and they say it's a cream puff, the court's going to say, you guys are two car dealers, you knew each other was lying and trying to sell the car and we're not going to hold that against you. That's important because otherwise you can spend hundreds of thousands of dollars litigating about what everybody said before they signed the contract. And if you have a valid non-reliance provision in your contract, you can skip all that and get the case resolved relatively cheaply so you don't have to spend your dollars paying a lawyer.